All right, good morning, everybody. For those of you who don't know me, I'm Michael Scharf. I'm the Dean at Case Western Reserve University School of Law. And on behalf of the law school, it is my great pleasure to welcome you to the second of our Case Downtown lectures for this year. This is a series that we launched a couple of years ago in an effort to get our most distinguished faculty members down to the Cleveland area where it is convenient for people to come and listen to some cutting-edge topics over breakfast before heading off to work. Today, we are very excited to have one of our most promising young professors who I was privileged to have been on the chair of the hiring committee the year he was hired, come to speak to you about a topic that is in the cutting edge of business law. And I see looking out that we have a small but intensely eager and interested audience. We're also videotaping this, so those of you who weren't able to come down today can watch this over and over and over again for CLE credits. But let me tell you a little bit about our speaker. Charlie Korsmo started out his career not in law, but he was actually working in the field of Hollywood acting as a child star in several movies. Let me just ask, have any of you guys seen Charlie in, for example, the movie Hook? Yeah? Okay, everybody's raising their hand. Dick Tracy. Yeah? What about Bob? Can't Hardly Wait. Well, after a very successful career as a child actor, Charlie realized that he was too wicked smart to stay in Hollywood, and he went off to MIT to get his undergraduate degree, then Yale Law School. Then he clerked on the Second Circuit for Judge Wisdom, right? Judge Winter. Then got jobs in Washington, D.C., and then we started heavily recruiting him, and it was one of the most fortunate days of our law school when we were able to obtain him as an assistant professor 5 years ago. Now, since then, Charlie has literally rocketed up in the ranks of highly cited published professors. You can read about him often in the New York Times, in the Wall Street Journal. His work is being cited by many court cases and experts in the field. Now, our law faculty this year had the privilege of being ranked 25th best law faculty in terms of scholarly impact. And that has a lot to do with people like Charlie and my other colleagues who are really having a great couple of years of publishing and doing our part to change the legal world. So without further ado, please join me in giving a warm welcome to Professor Charles Korsmo.
Thank you, Michael. I wasn't sure that Dean Scharf was going to be here this morning, so I have like a 3-page introduction of myself here that I can skip right over now. Well, thank you again to Dean Scharf and also to the City Club for hosting this event and the organizers of the Case Downtown series. And thank you all for being here this morning. So my topic this morning is, as Dean Scharf, I believe, mentioned, Stockholder Appraisal, which is a topic that hadn't really gotten a lot of attention among legal academics and even until recently hadn't gotten much attention among practitioners either. And unless you follow this stuff, it may never even be something you'd have heard of, Stockholder Appraisal. But so just to give a little bit of background, and I know there's some people here that are very familiar with it, but others might not be. In a nutshell, what stockholder appraisal is a statutory remedy that allows minority stockholders to dissent from a merger transaction. To say, I vote against this this merger transaction, forego receiving the merger consideration. I'm not taking your filthy money, and instead going into court. And seeking the fair value of the shares that are canceled in the merger as decided by a judge. And almost every state has an appraisal statute of one kind or another. And there's a lot of common similarities, including Ohio, of course, has it, although it's not one that's been used a lot. With my co-author, Minor Myers at Brooklyn Law School, I've done a lot of research on appraisal. Mostly focusing on Delaware, as that's sort of the seat of corporate law in the United States and certainly the hotbed of appraisal litigation. And our work has finally started to, as Dean Scharf mentioned, find its way into print over the last year or so, and has gotten a little bit of attention as one of the few sort of scholarly articles on a topic of increasing relevance. And our work first started to get some attention during the dust-up over the Dell merger a couple of summers ago, where Michael Dell was taking Dell private. And there was a lot of controversy over the process and the price he was paying, whether it was a fair price. And Carl Icahn, the famous activist investor, was opposing the merger and threatening to pursue appraisal. Now, at the end of the day, Carl Icahn didn't seek appraisal, but a bunch of other people did. And it got a lot of national attention at the time, and we started actually getting calls from folks to sort of lend our research to them. And full disclosure, I have provided compensated advice on appraisal, so I'm now a shameless shill for appraisal litigation. But I hadn't done that at the time I did this research, so it should be relatively unbiased. Okay, so there's maybe 2.5 points that I want to make this morning. I'll start by just making the case that something very different has been happening in appraisal litigation over the last few years. The amount of litigation has changed. The identity of the people involved in litigation has changed. The entire landscape of appraisal litigation has changed. Then, the second point I'm going to make is that the litigation that has happened over the last 10 years or so actually bears some markers of merit. That is, it tends to be fairly meritorious cases that are being brought, which is for people that have studied a lot of merger litigation, especially fiduciary duty class actions. That's not always the case. There's a picture that's not entirely inaccurate of stockholder litigation as being rife with nuisance suits and weak merits in terms of the litigation, and that's not what we observe with appraisal litigation. And then I'll conclude my sort of half point that I want to make at the end is to give some tentative thoughts of what sort of legal responses, if any, this new appraisal world might call for. And of course, I'm happy to talk about what a practitioner might need to know about appraisal and might want to how they might want to respond to it in terms of transactional practice. So first, let me just give you a glimpse of what I think is the standard presentation of appraisal in law school corporate law courses. The sort of textbook version of appraisal. And I'd say it's not a very prominent topic at all. I'd say it occupies a position of prominence somewhere between books and records requests and the doctrine of waste, in that it's something you hear about. It's sort of covered in passing in law school, but not a lot of time is spent on it. The overall message is there's nothing interesting to see here. Especially when it comes to large publicly traded companies. And I have just some representative quotes from prominent law professors about appraisal. I'll just read the one from Fried and Gaynor here. Right? The shortcomings of the appraisal remedy are widely known. Commentators have long recognized that appraisal is a remedy that few shareholders will seek under any circumstance. And that's really been the conventional wisdom for the past 100 years or so. And these are not new. The appraisal is not new. It's been around for about 100 years. But until recently, the conventional wisdom that it's just a sideshow at best. It's not something a lot of people are doing. And similarly, the usual picture given of who brings appraisal is, at least with a publicly traded company, is that it's brought by fairly unsophisticated small shareholders, which is true. It was true. I mean, such people are out there, and I'll just give an example. There was a case in 2007. A fellow who owned 1,000 shares of a sporting goods company called K2. And dissented when it was acquired by Jarden, Inc., another sporting goods company. And he filed his petition pro se in December 2007. And after 2.5 years, with zero litigation activity. He hadn't done anything to follow up on his petition. Vice Chancellor Noble of the Delaware Chancery Court notified the petitioner that he was in danger of having his suit dismissed for failure to prosecute the claim if nothing happened within 60 days. The petitioner responded by going straight to the top, wrote a letter straight to the Chief Justice Steele of the Delaware Supreme Court explaining the situation. I've got a little blow up here, right? Without being currently registered with a stockbroker and without electricity, email, a driver's license, nor now telephone, it would be difficult to dispose of such stock. I would have to walk through 2 evenings to make such a transaction, the fees of which might equal the value received. I believe the closest stock firm is 25 miles from here. Right, that's kind of your classic picture of pro se litigation here, and this was kind of the archetypical appraisal petitioner until recently. But now that old archetype is deeply misleading. So what have I done with my co-author? My co-author and I have collected every appraisal petition filed in Delaware since the beginning of 2004, which is when electronic documents become available for. And have studied these, right? And from 2004 through the end of 2014, and I'll mostly be talking about that period. I might talk a little bit about 2015, but it's not over yet, so it's hard to make any sort of firm comparisons. But there were 158 appraisal petitions challenging 108 public company transactions, so multiple petitions for some transactions. But 108 public company transactions were challenged in a total of 154 appraisal petitions. There's also a substantial number of petitions charging involving private companies. Those tend to be less raise fewer sort of policy or legal issues. So I'm going to be focused on public companies. As I say, only part of the year is over for 2015, but it looks like it's going to continue the trend that's happened over the last couple of years. In short, this seems to be an area of litigation that's changing rapidly. First of all, the amounts of money involved in appraisal claims has risen dramatically over the last few years. So here's a chart just showing the amount of money that went into appraisal petitions in constant dollars here. This is all adjusted for inflation. And what do I mean by the amount of money that went into appraisal? Well, when you seek appraisal, you have to forego the merger consideration, right? So say the company, Company A is being bought by Company B for $20 a share. If you want to seek appraisal, you have to say, don't give me the $20 a share. Instead, I'm going to court and seeking a declaration of the fair value of my shares. So if you had 1 million shares, you would have to forego $20 million in merger consideration in order to pursue the claim. So that's what I mean by the number of dollars in appraisal litigation. And this reflects the holdings not only of people that actually sought appraisal by filing a petition, but of where possible, where we could find the information, other shareholders who dissented from the merger but didn't end up filing their own petition. They just appeared on what's called the verified list as people that were part of the appraisal class, so to speak, but weren't pursuing it personally. And as you can see, before 2013, the amounts involved in appraisal were quite small, 2005 being the one exception, but 2005 is almost entirely a function of one very large case, a case called Transkaryotic, where approximately $500 million in current dollars was involved in the case. If you take that out, it looks much more like 2006, 2007. But starting in 2011 and continuing through 2014, the amount really increases very quickly. At the same time, more transactions are attracting appraisal. Not only are the amounts in appraisal going up, but the number of transactions targeted are going up too. So what this chart shows is the percentage of appraisal-eligible deals that are targeted for appraisal by year. And as you can see, it sort of bounced around 5% until starting to climb in 2011. And we've reached a new, well, it's hard to say whether it's an equilibrium yet, but the last couple of years we've been in the range of 15 to 20%. 3 times the amount of litigation we saw prior to the more recent period. Now, this doesn't include 2015 numbers. This ends at 2014. But so far, the percentage of deals targeted in 2015 looks very similar to 2013. It's at the high end of this range. It looks like it's going to be at least 15%. And the value of appraisal, actually, if we go back to this slide, in 2015 is at an all-time high. We're up to $2.3 billion already in October, which is about half again as large as the amount in 2013, which was the prior all-time high. Now, that's heavily concentrated in a handful of deals. There's 2 very large appraisal claims pending right now involving PetSmart. PetSmart and Safeway, each of which one of them is around $800 million and the other is around $600 million. So almost 2/3 of 2015 dollars involved are these 2 cases, and then about half of the rest is a case involving AOL. Believe it or not, someone's saying they didn't get enough money for AOL, which maybe that's true. All right. Now I should say this is almost certainly an underestimate of the amount of actual appraisal litigation that's going on, in that this only counts if a petition was filed in a case. And under Delaware's statute and most appraisal statutes, you have 120 days. You have until 120 days after the close of the merger to file a petition, and you can be negotiating a settlement all along the way, right? So it's surely the case that some claims are settled without a petition ever being filed. Now, we suspect those are actually particularly strong cases that get settled quickly. So the figures I'm going to present about the comparative merits of appraisal petitions likely understate the actual merits of the claims that are being brought where petitions aren't filed. Okay, so we have a huge increase in the amount of appraisal litigation. And another trend is that the parties involved in appraisal litigation are increasingly sophisticated and are increasingly repeat players. That is, instead of having sort of your one-off guy in his cabin in New Hampshire shooting off an appraisal petition, you have sophisticated hedge funds that are deliberately pursuing appraisal as a strategy and that are doing so repeatedly. Right? They show up again and again. So the character of the typical appraisal petitioner has changed since 2010. Prior to 2010, filing an appraisal petition was largely a one-off activity. Even if it wasn't your pro se plaintiff, it was a fund that was using it as sort of a last-ditch attempt to salvage their investment. It was just being used opportunistically, if at all. Whereas since 2011, almost all of the value in appraisal involves repeat petitioners. That is, people that have filed more than one petition during our period. Now, this chart only goes through 2013. More recently, it's become a little harder to define a repeat petitioner, in that there's lots of sort of related entities, and the companies themselves have made it a little harder to tell who's on the verified lists and how many shares they have. So it's harder to collect the data in recent years. But we have reason to think 2014 and 15 look a lot like 2013 in terms of the percentage of value held by repeat petitioners. Now, one crucial feature, you might wonder, well, how can a repeat petitioner get involved in appraisal in the first place? How do they have standing to get in? One crucial feature of appraisal that has enabled the rise of repeat petitioners is that in most states, including Ohio, again, although it hasn't been done all that much, you can buy into an appraisal claim after the merger has been announced. That is, the merger is announced, they announce the terms of the deal, it's going to be $20 a share. A would-be appraisal arbitrageur, or a would-be repeat petitioner fund, can look at the merger documents, can look at the preliminary proxy, and can decide whether or not to buy the stock after the merger has been announced. And once they buy in, they can still dissent and seek appraisal. So it's a little bit different than than other kinds of litigation, and certainly than other kinds of stockholder litigation, where it's possible to invest in a claim in a way that is not always possible with litigation. So we've called this activity appraisal arbitrage, which I don't think is the best name for it, but it's kind of stuck for one reason or another. Right, the practice of buying stock after a merger is announced, with the intent of seeking appraisal and making your investment return through appraisal litigation, has come to be known as appraisal arbitrage. And there's a handful of very large funds that are doing this. The single largest one, I believe, is a fund called Marion Capital. It was founded by a guy named Andrew Barraway, who's a former plaintiff's attorney, which is not that surprising, I suppose, but they've raised a fund with about $1 billion in committed capital that has gone into appraisal. Another big repeat player, there's a couple of big multi-strategy funds that have started doing this. Verition, a big New York-based hedge fund, or Greenwich-based hedge fund, I suppose it is, New York area-based hedge fund, and Magnetar. And I won't talk about any local funds, but there's other players too. All right, so let me mention. I'm going to talk about why this might have happened. Why the increase in appraisal litigation. But let me say at the outset, one explanation people have given that's become sort of a hot button. There's some people that are very angry about this rise in appraisal activity. In particular, there's a group of very influential New York deal lawyers, New York-based merger advisors, essentially, that think appraisal arbitrage is really an abuse of the appraisal statutes. I think they could be accused of speaking their pocketbook, right? Anything that complicates merger transactions is going to be a bad thing for deal lawyers. But there's a lot of explanations for why this increase in appraisal litigation, and what can we do to sort of put a lid on it. And one is focuses on the statutory interest rate in Delaware. In Delaware, I believe it was 2007, they amended their appraisal statute to provide a fixed rate of interest, a statutory rate of interest on appraisal judgments of the Fed funds rate plus 5%, which, so if you litigate an appraisal claim and it takes 2 years from the close of the merger, you get whatever the fair value of your shares is plus interest at the Fed funds rate plus 5%. And in an era of near zero interest rates, that's arguably a very attractive thing to be able to get. Now, the fundamental problem with this, and here's the Fed funds rate, or the interest rates on 2-year Treasury notes, anyway, which is approximately the Fed funds rate over the past 10 years or so, I guess 9 years. The problem with this explanation is it doesn't really line up with the increase in appraisal activity. Right, there's about a 3 or 4 year lag from the time of the new interest rate regime and the increase in appraisal activity. So if you look at appraisal volume, you just don't see a very close connection. And same thing with the incidence of appraisal. It looks maybe a little bit correlated, but the relationship just doesn't really stand up when you look at it. Now, I have no doubt that Fed funds rate plus 5% is an attractive feature of appraisal, and frankly, we don't have that in Ohio. In Ohio, it's the discretion of the court to set the interest rate at an equitable amount. But you only get interest, first of all, if you try a case all the way through judgment. It's going to drive the settlement value, but in most cases settle, and you're not entitled to interest on a settlement. And frankly, it's not clear to me that the Fed funds rate plus 5% is really excessive compensation for the risk that an appraisal petitioner bears. Right? An appraisal petitioner holds an unsecured claim of uncertain amount and uncertain maturity against some company, right? Whose cost of borrowing may actually exceed 5% plus the Fed funds rate. So it's not entirely clear to me that this is an overcompensation for the risk involved. At any rate, it doesn't seem to me to be a powerful explanation for the rise in appraisal activity. I don't have a perfect explanation myself, but I think it's more than just a play on low interest rates. That doesn't seem to be what's going on. All right, so the picture we have so far is that we have appraisal is an area of corporate litigation that's rapidly changing, it's rapidly expanding. What are we to make of these developments? It's become a subject of heated debate, particularly in Delaware. Is this kind of arbitrage, appraisal arbitrage, an abuse that's enriching a group of specialist hedge funds essentially at the expense of other shareholders, minority shareholders? Or is it a good thing? It could be a salutary development where we have a form of corporate litigation, shareholder litigation that provides real deterrence against opportunistic mergers and in a way that redounds to the benefit of all stockholders. And it's not immediately clear what the implications of this rise in appraisal litigation are, either for corporate governance generally or for the structure of appraisal in Delaware. Now, in trying to answer these questions, is this a good thing or a bad thing, I think it first makes sense to ask, well, do the claims that are being brought look meritorious? That is, are they targeting the right deals? Are these appraisal arbitrageurs targeting the right deals? If we want appraisal, the positive story for appraisal, right, would be, well, it deters opportunistic transactions, things like management taking the company private and squeezing out the minority shareholders at an abusively low price, right? We want to deter things like that. We want to compensate shareholders who have been treated like that, who have been taken advantage of. Well, if appraisal is going to do that, then a necessary condition, not a sufficient condition, but a necessary condition, is that appraisal arbitrageurs have to be targeting deals where we think there's an unusually high chance that shareholders have gotten too low a price, that they've been handled opportunistically. So my co-author and I have tried to provide an answer to that question, at least a tentative answer to that question. And for reasons I'll explain, we kind of expected these claims to be meritorious. To look better anyway than the far more common type of merger challenge, which is a fiduciary duty class action. And here's what we find. I mean, in appraisal, where we think the risk of opportunism in litigation anyway is low, we do find markers of litigation merit. By contrast, when we compare it to fiduciary duty class actions, where we think there's a high risk of opportunistic litigation, we find a lack of markers of merit. And in most shareholder litigations, like shareholder fiduciary duty suits, class actions, the fundamental problem is that you have a serious agency problem between the stockholders on whose behalf the claim is at least nominally brought, and the plaintiff's attorneys, who actually control the prosecution of the claim, who represents the shareholders. In the standard shareholder class action, a derivative suit or a securities class action, it's always going to be brought in a representative capacity. That is, the named plaintiff and its attorney presumptively represent all stockholders of the company, right? It's a class action. It's a class of all stockholders. And the result of this is that you've got a very dispersed plaintiffs group with most companies. And the real powerful incentives, the real concentrated incentives, economic incentives, are all going to operate on the plaintiff's attorney, not on the stockholders themselves, because the attorney's fee is going to be taxed against the recovery. Right? They're going to recover their attorney's fees out of whatever the class recovers. And professional plaintiff's attorneys are going to control decisions about when to initiate litigation, about how to prosecute litigation, about how to settle the litigation. It's going to be the plaintiff's attorney really driving that process in conjunction with the defense attorneys, right? And the risk is, I think, pretty obvious that the plaintiff's attorneys may use their discretion, the sort of lack of real oversight from the stockholders, to help themselves at the expense of the stockholders. Strong suits might be settled very quickly for large attorney's fees paid out of the settlement. And because it costs almost nothing to bring a class action, a plaintiff's attorney can bring a class action on behalf of someone who owns 100 shares, and they don't even need to forego the merger consideration, right? They're already paid. The merger consideration costs almost nothing to bring a fiduciary duty class action, so it's very easy to bring a nuisance suit. It's very easy to bring a meritless claim and then just, this may be too pejorative a term, but extort a settlement for attorney's fees, essentially, that avoids the need to litigate a claim. And that can be easy to do because even though the court needs to approve any settlement, there's a whole range of remedies you could include in a class action settlement that would allow a court to say, okay, it's fine that it provides something to the shareholders, and you can still get your $1 million in attorney's fees as a result. And the so-called disclosure-only remedy is sort of archetypical here, right? That there's a class action brought against a merger, and they end up settling for additional disclosures. Remedial disclosures. The company's going to disclose a lot more information to the shareholders about the deal, and the attorney walks away with, on average, $750,000 in attorney's fees, and the shareholders don't get any actual money, but they get additional disclosures. Very typical pattern. Now, appraisal is very different, and it's that difference that offers us a unique chance to sort of investigate the role of plaintiff's attorney agency costs on the merits of stockholder litigation. So first off, you're not bringing appraisal petitions on behalf of a class. Only shareholders who affirmatively opt in by meeting certain fairly stringent procedural requirements are a part of the appraisal class, so to speak. It's an opt-in class, and it's expensive to opt in. Right? You need to both follow some fairly complicated procedural requirements, and you need to forego the merger consideration, right? And you need to buy up a big enough position to justify the costs of litigation because it's not a class action. You're bringing it only on behalf of yourself. So if you've only got $10,000 worth of stock, it's no matter how good your claim is, it's not going to be worth bringing a claim. So if you're an appraisal arbitrageur, you need to get millions of dollars worth of stock in order to have it be worthwhile, and you need to forego the merger consideration on that stock. So you're sitting there with an illiquid position of millions of dollars. It's expensive to opt in. Right? Second, there's no provision to allocate the plaintiff's attorney to the defendant. The defendant can't just sort of offer to pay off the plaintiff's attorney. And even if they could, you've got a real plaintiff with a real financial stake that's supervising the attorney, in contrast to most fiduciary duty class actions. The only route to a fee is through a recovery to the plaintiff. So you're not going to see disclosure-only settlements. In fact, the only remedy available in appraisal is cash, right? The cash value of the shares. So there's no way to structure a remedy, right? A settlement that benefits the lawyers without benefiting the clients, and that cash is the only way, right? So given these differences, we expect to see fewer agency problems and greater litigation merit. It's going to be expensive to bring a nuisance suit and not going to do you much good. And it's going to be impossible for a plaintiff's attorney, impossible, but very difficult for a plaintiff's attorney to settle a claim out from under the stockholders, right? The merits ought to matter a lot more than they do in other cases. So again, to test this, our data comes from the Chancery Court, the Delaware Chancery Court's dockets. We're looking at appraisal petitions filed between 2004 and 2014. We're pretty confident we've found the entire universe of cases, or at least something quite close to it. As I said, we identified 158 appraisal petitions. These involved 108 separate public company transactions. The value at stake was large and increasing. The mean value of an appraisal petition was $36 million over this period, and the median was $2 million. Half of all claims were for over $2 million. Pro se litigation, a little unusual, but not entirely unheard of, even in public company litigation. We had 7 pro se petitioners, and even the pro se petitioners had a significant amount of money involved. The mean value was over $500,000 for pro se petitioners. Settlement is the predominant outcome. We don't know anything about the settlements. because it's not a class action. It doesn't need to be made public. They don't need to publish or defend it in open court, so we don't know a lot about the settlements. But the claims went to trial in about 10 to 15% of cases over our period, which is actually a very high number for shareholder litigation. Usually, it's more like 3 to 5%. End up going to trial. Here it's two or three times that amount. So right off the bat, we have reason to think we're not seeing the traditional pattern of shareholder litigation. We have petitioners that have meaningful economic stakes, big economic stakes, and we have a non-trivial incidence of trial here. So to analyze this litigation further, we identified a larger universe of merger transactions that were appraisal eligible. That is, somebody could have sought appraisal in those transactions, and we limited the set of transactions to ones for which all of the data we needed was publicly available. It's approximately 1,500 transactions. And for those transactions, we hand-collected data both on the appraisal petitions and on fiduciary duty class actions, fiduciary lawsuits that shareholders filed challenging the deals. And we found, remember, there were 108 deals involving appraisal petitions. There were 800 involving fiduciary duty class actions, so 8 times as much action. And then we can use that data, this combined data, to examine the decisions of stockholders and their attorneys, right? Which transactions were selected for appraisal? Which transactions were selected for fiduciary duty complaints, right? That's what we're trying to do. And our principal test looks at the attributes of the deals that appraisal plaintiffs are challenging. That is, how are they selecting cases for litigation? And what we're looking for is merit, right? Was the case they brought meritorious? And usually that's kind of hard to assess, right? I mean, if you're bringing a fiduciary duty complaint, you're saying, well, the director, violated their duty of loyalty, they committed fraud, right? Without discovery, it's hard for us, just looking at the complaint, to decide, well, was this a good claim? Was this a bad claim? What were the merits of the claim? Unless we could actually try all of these claims, it would be impossible to tell. We think it's a little different in the appraisal context, where there's really only one issue. What's the fair value of the stock? We really only have one variable that ought to matter, right? The price of the shares. And we think the comparison to fiduciary duty class actions and targeting the same mergers is almost apples to apples, in that at the end of the day, whatever else might have gone wrong in a merger transaction, the only thing that shareholders really care about is likely to be the price that they're getting, the amount of money they're getting for their shares at the end of the day. So the basic questions we're going to ask are, well, are appraisal petitioners challenging deals where the merger price is unusually low? And are fiduciary duty complainants challenging transactions where the merger price is unusually low? Or are they just targeting large deals, deep pockets, where the nuisance value of a claim might be thought to be especially high? And to answer these questions, we looked at 2 things. First, deal size. Do appraisal petitioners disproportionately target large deals? And as you can see on the right here, I guess it's on the left. On the left here, the mean equity value of deals not targeted by appraisal petitions is about 1.9 billion, 1.86 billion, and ones targeted by appraisal petitions is about 2.7 billion. So at first blush, it looks like, well, appraisal petitioners are targeting larger deals, but in fact, that effect is entirely driven by the handful of pro se petitions we have. They're targeting very large deals with a mean size of about 21 billion. The counseled petitions, which tend to be much larger, much more economically important, are actually targeting slightly smaller deals than average, about 1.4 billion in equity value. The difference isn't statistically significant, but it doesn't look like they're targeting large deals. Let's see here. And here's actually, this is what's called a kernel density plot. It's essentially just a smooth histogram, and it's comparing deals that were targeted by appraisal petitions. The equity value of the companies being bought is the green line, and the black line is all appraisal eligible mergers. And you can see they look pretty much exactly the same. And this holds over various measures of size. I could look at enterprise value or any other sort of standard measure of size and show the same thing. So deal size doesn't appear to matter for appraisal petitioners. So the question is, does the size of the merger premium matter, right? The premium over the prevailing market price of the stock that's being paid by the purchaser, right? And the easy way to do that would just be to sort of compare the raw premium, right? Well, how much did the stock go up after the merger deal was announced? And when you do that, you see a big difference. But we wanted to make sure that's not just a sort of an artifact of other differences between the deals. So we used a derived premium, what we call the residual premium, which tries to control for other things that might affect the premium that a company is paying in a merger transaction. In particular, the size of the transaction, the year that the transaction took place, the industry and type of business involved, and calculated a residual premium. And we can see the results here for deals not attracting appraisal. That's the top line, and you can see on the left the one-day premium. That is the premium to the prevailing market price of the stock the day before the deal was announced. It's pretty close to zero for deals not attracting appraisal, 1.7%. And the mean one-day residual premium for deals that do attract at least one appraisal petition is very largely negative, particularly for counseled complaints, but even for pro se complaints. For counseled complaints, though, the merger premium is 14.7%, percentage points less than we would expect. Based on the other characteristics of the deal, right? So it looks like the stockholders in those deals were getting much less than we would have expected them to get, which is good for appraisal, right? They're targeting deals where the premium is less than we would expect. And here's a histogram of that. You can see the green line is deals attracting appraisal, and you can see that shifted way over to the left here. You've got a big difference between the deals not attracting appraisal and the deals that do attract appraisal, and that holds against any measure of merger premium that we used here. Right, the appraisal deals are all shifted left. They have lower premia, and it's all statistically significant at the 1% level, very highly statistically significant. So, here's what we've got, right? We have counseled appraisal petitioners attacking deals with smaller than average merger premia without regard to the overall size of the deal. So it's actually looking pretty good for the merits of appraisal petitions. And I won't go through all of these regression panels here, but except to highlight that the deal size, which is the second row here, and is not statistically significant, right? No stars up there is all you really need to see. Whereas the residual premium is highly statistically significant. You've got at the 1% level, 99% confidence on all of these that the smaller deal premium is significant. Okay, what about fiduciary suits, right? We'd like to compare this to something. So let's look at fiduciary suits, the usual pattern, or the far more common type of stockholder litigation. And again, we've got 1,500, the same 1,500 deals, and we've got 800 fiduciary class actions filed against these suits. And in recent years, something like 85 or 90% of deals are challenged by at least one fiduciary transaction. It's become ubiquitous here. So we looked at the same metrics. First, deal premium, right? Here, the mean residual for deals not attracting a fiduciary suit, that's the top line here, is 2.6%. And the mean deal premium for a residual deal premium for suits attracting at least one fiduciary duty class action is only a tiny bit negative, right? 0.9%. And this difference isn't statistically significant. Not much different. And in fact, deals that attract a real frenzy of fiduciary duty class actions, 5 or more separate filings, actually have higher than expected merger premium, 5.3%. Now, again, that's not statistically significant, so I wouldn't read too much into that, but it doesn't look like they're targeting abnormally bad deals, and you can see this on our kernel density plot. Not much difference, in fact, no detectable difference between deals that do attract a fiduciary suit and duties that don't. Okay, if fiduciary duty claimants, and really we're talking about plaintiffs' lawyers at this point, the class action lawyers, aren't targeting deals with abnormally low merger premium, what are they doing? Well, they're targeting big deals, right? So the average size, the mean size of deals not attracting a fiduciary duty suit is $1.16 billion. And ones that do attract a fiduciary suit, at least one, $3.2 billion, almost 3 times as much. Highly off the charts statistical significance here. And ones that attract a frenzy of fiduciary duty litigation, the mean size is $7.7 billion, 7 times what it is for deals that don't attract a claim. And again, we can see this on a kernel density plot. Deals attracting a fiduciary duty suit are highly shifted to the right. That is, they're bigger deals. They're targeting deep pockets here, and they're leaving alone the small fries that they don't think they can get a decent fast settlement from. And this holds against, again, here's the regressions. You can see deal size here is highly statistically significant, got the 3 stars, whereas the deal premium is not statistically significant, except for the number of fiduciary suits, in which case the statistical significance goes the other way. Actually, they're targeting deals with larger merger premium, not what you want to see. Deal size is really the predictor. And here's the basic story all in one slide here, right? This basically shows our entire findings graphically. Appraisal. You're looking for deals that have an abnormally small deal price, abnormally low deal price, whereas fiduciary duty litigation, the more standard type of litigation, you're looking for large deals. That's where you're going to get the action. So the appraisal suits, answering the question we set out to ask: are the appraisal suits meritorious, or do they at least appear meritorious? The answer is yes. We seem to be targeting the right deals in appraisal arbitrage, and this finding is consistent across both the pre-appraisal arbitrage period and the post or the current appraisal arbitrage period. So it looks pretty good. All right, so the last thing I want to touch on is just what to make of this new world of appraisal litigation. And I'll note that I'm not generally an optimist about shareholder litigation. You could classify me as someone with deep skepticism about whether shareholders really benefit at all from most forms of stockholder litigation, derivative claims, fiduciary class actions. But appraisal looks very different to me. The classic problems of shareholder litigation don't seem to be there. They seem to be absent. And indeed, appraisal claimants seem to be challenging the type of deals that look like they ought to be challenged in one way or another. As a result, my co-author and I think that appraisal could serve as a useful check on managerial opportunism and abusive deals. Now, some have said, well, even if it is a useful form of shareholder litigation, isn't it just sort of a group of specialist funds benefiting themselves at either at the expense or at least to the exclusion of minority shareholders? And I think that's a bit of a red herring in that minority shareholders are going to benefit from any deterrence value that appraisal litigation has. If it's deterring abusive transactions, minority shareholders are going to benefit from that. The best example of that is probably Dell. So Michael Dell is taking the company private, and Carl Icahn starts raising a stink about he's going to seek appraisal for his shares, and it was explicitly done in response to those threats. Michael Dell upped his offer by $400 million. Right, so shareholders got $400 million more than they would have because of this threat of appraisal. Now, it's not usually that obvious that the ability to draw that connection. But deterrence like that can work. Less directly, appraisal arbitrageurs have to come in and buy their shares. after the deal is announced. And in an increasingly competitive market for appraisal arbitrageurs, we're often seeing prices being paid above the merger price to get the shares. So in some sense, they're sharing the value of the expected value of the appraisal claim with the existing shareholders. And if the market becomes even more competitive, we would expect them to bid that right up to the expected value of the appraisal claim. All right, so this leads us in a few directions. First of all, we think that some of the attributes of appraisal, the structural attributes of appraisal, could be used to reform other types of shareholder litigation to make them more meritorious. But what about the future of appraisal itself? As I said, it has some powerful opponents. And in light of our findings, we think that the opposition to appraisal presents something of a puzzle, given that it seems it's, first of all, far more targeted, far less common, and second of all, seems focused on especially bad deals. Why are people up in arms about appraisal arbitrage, but not the fact that 90% of suits or 90% of deals get attacked by fiduciary duty class actions? It seems like a strange set of priorities. And there hasn't really thus far been any real serious explanation of how appraisal arbitrage poses a real threat to the deal market. But I do think it's going to raise issues for the Delaware courts. Formally, an appraisal claim is just what's the fair value of the shares. It's not a Revlon claim. It's not a fiduciary duty claim. The process by which the deal was arrived at is formally not relevant. But as you get larger and larger claims, more economically significant claims, the question of, well, how should the court consider the negotiated price of the company? When is that relevant? And we've seen in several cases over the last couple of years the Delaware courts defaulting to the deal price, essentially, and saying, well, if you can't point me to something that went wrong with the deal process, then who am I to second guess sort of the market for corporate control here, right? Who am I to come in and say, if you couldn't find, if the board did their best selling this company and couldn't find someone willing to pay more, how am I going to come in as a judge and say, well, the company was worth 40% more than the negotiated price? It was a very striking case from about a year ago involving a company that the major asset of the company was the royalty rights for American Idol, the TV show, right? And it was right before their contract for American Idol was up for renegotiation that this merger happened. And just none of the usual metrics for measuring a corporation's value were all that useful. You couldn't project cash flows going forward. There were no comparable companies to American Idol, right? American Idol's, I guess you could look at The Voice, right, and see what that's worth, but hard to do. And the court sort of ended up throwing up its hands and saying, well, where I can't do any better, then the results of an arm's length negotiation are the best evidence of fair value. So I'm just giving you the merger price, and we've seen that in a couple cases over the last few years. What we're concerned about, though, is that the increase in appraisal might create sort of a knee-jerk reaction from either courts or from legislatures to try to sort of tamp down on the amount of litigation. And given the merits we see in appraisal litigation, I'm inclined to be skeptical of any legislative response that would actually reduce its availability. In fact, I think a case could be made for expanding its availability. But these are all just preliminary thoughts. I see I've gone on way too long, so we still have a few. We started a little late, so we have a few minutes for questions if people have them. I'm happy to talk about. We have a microphone even.
Just a basic question.
Sure.
Why would companies be willing to accept a price that's too low, the acquired company?
Well, just to give a really easy answer for that, say you've got a stockholder who owns 51% of the company, who already has 51%, and they can approve any transaction they want, and they can reject any competing bid that they want. So they could create a merger proposal to take the company private and pay as low a price as they can possibly get past the Delaware courts, essentially, right? It could be worth $100 a share, and I'm only going to offer $1 a share, but I'm going to accept it, right? Because I'm both paying it and getting it, and I'm just extracting value from the minority shareholders. So that would be a really blatant situation. There's other cases where the management's incentives differ from those of the shareholders. Right, they're going to get a big golden parachute if a transaction goes through, so they're eager to sell the company even at less than fair value, or they're going to be hired on and continue to control the merged company. Right, so they have interests in their employment contracts that are adverse to the shareholders' interests, and it could just be negligence too. Right? It could just be negligence too. But the really major problems are when you have a conflict of interest between either the acquirer, who's a controlling shareholder or otherwise, or the management team and the shareholders they're representing. Make sense?
Besides the deal premium, have you looked at any other ways to measure the fairness of a deal?
I mean, it's hard to. I'd be open to any suggestions, frankly, on how you might do that. I mean, we've looked at. We've looked at the identity of the purchaser, right? In particular, if it's a management buyout, or if it's a controlling shareholder transaction. And the problem is it gets tough. You get a pretty smaller sample size with any of those, so it's tough to get much statistical significance. I mean, it certainly appears statistically significant that when you've got 13E3 or something filed, you're much more likely to get both an appraisal claim and a fiduciary duty claim. Beyond that, I mean, it's hard to say how you would measure, because it's really a one-issue proceeding, right? It's hard to know how you would measure the merits, at least in a non-hugely labor-intensive way. You could go in and try to perform your own valuation of the company, right? But two poor law professors doing hundreds of public company valuations would be tricky, and it would still be very debatable, right? So we're trying to stick to something as simple as it could be, right? I mean, it's a crude measure of the merits. But we get such a big effect even from that crude measure that we feel confident in at least stating that the effect exists, even if the magnitude of the effect is somewhat uncertain. But I'm happy to get any suggestions on a labor light way of measuring the merits. Okay. Well, thank you all for coming. I hope it was informative.